Hi, it's Shan Wu with a undercolor of law analysis of the latest important Supreme Court decision. Notice I said decision. It's not really a fully briefed or argued case. They did issue some opinions, but this is the one about the airlift, for lack of a better word, of Venezuelans to El Salvador to imprison them. This is the one where the U.S. District Court Judge Jeb Boasberg had ordered them to turn the planes around. They didn't. And he's held further hearings after first imposing a temporary restraining order on the government from continuing to do that. He's holding hearings to get answers and possibly to hold the government in contempt. But in the meantime, the Trump regime took this up quickly, asking the Supreme Court to step in. And the court did step in a very limited fashion, though, and that's what I want to break down for us. They said that the TRO has to be lifted, so there's no longer a freeze. But that doesn't mean that the administration can go back to just wholesale snatching people, putting them on airplanes and sending them to this sort of supermax, very dangerous, bad prison in El Salvador. They were using the Alien Enemies Act, and one of the issues before Judge Boasberg and theoretically before the Supreme Court was, can you even do that, right? Alien Enemies Act is for alien enemies. We're not at war. Who are the aliens? Who are the invading enemies? Where is the war, right? Supreme Court didn't decide that. So it's only a decision that sets forth how people who are detained can challenge their deportation and where they have to be challenging it, meaning what court do they use. So let's break this down a little bit. So here's what's not being considered, and the Supreme Court lays this out very clearly, and we'll explain the way the sort of justices broke down on this, but this is the majority. I'll read it to you. We grant the application and vacate the TROs. The detainees seek equitable relief against the implementation of the proclamation and against their removal under the AEA, the Alien Enemies Act. They challenge the government's interpretation of the act and assert they do not fall within the category of removable alien enemies. But we do not reach these arguments. Challenges to removal under the AEA, a statute which largely, quote, precludes judicial review, unquote, can only be challenged under habeas corpus. That's what they're concluding. Now, this is critical to drill down on a little bit because the Trump government keeps arguing that anything under national security, Alien Enemies Act, effectively non-reviewable. So they got a big loss on that point. They tried all sorts of nonsense before Judge Boasberg was asking for questions like, when did the planes take off? When were they told to turn around? Were they told to turn around after I said turn them around? The Trump DOJ was giving answers like, it's national secrets. They're trying to invoke those sorts of issues. They said it's attorney-client privilege, all a bunch of nonsense here. And the majority here, Supreme Court, makes it very clear that we're not actually talking about whether or not the planes could be turned around. We're not talking about can the Alien Enemies Act be used. What we want to talk about is how do you challenge your detention under the Alien Enemies Act. And what's important there is they said that anyone being detained under this must have notice, meaning we're going to detain you under this, and then you have to have a right to be heard, meaning judicial review. So that's a very important point, maybe the most important and maybe the only positive point that was made. A couple of details. We've talked about this before. It's an appeal of a temporary restraining order. As I said before, you can't normally appeal temporary restraining orders. No problem for the Supreme Court. They said, quote, we construe these TROs as appealable injunctions because a preliminary injunction can be appealed. So they kind of just blew through that, although there's real questions about why they're treating them this way. And one of the dissenting opinions takes exception to that. Second question, Judge Boasberg had said, I ordered the planes back. Why didn't you do that? He was looking at possible contempt against the government. Supreme Court completely doesn't address this at all. So now, though, it's not very good for the Boasberg inquiry because now you're talking about possible contempt for a vacated, defunct TRO, which the court actually says shouldn't have been in front of him anyway because of the type of procedure was being used. So much weaker case. And the dissent kind of points this out. Why is it a weaker case? This is going to sound really in the weeds and gives you a sense of the sort of technicalities that the Supreme Court is doing here. They're saying that you can only use habeas corpus. You cannot use anything else. This was not brought before Judge Boasberg as a habeas corpus case. It was brought as a class action for all potential Venezuelans who might be swept up in this and sent out of the country. Nonetheless, the court was in a big hurry to make this point, and the dissent doesn't like that. The dissent says that the district court ordered a pause on plaintiffs' removals until it could consider their motion for a preliminary injunction at a hearing tomorrow on April 8th. Still, a majority of the court sees fit to speak to the issue today. Not content to wait until tomorrow, when the district court will have a chance to consider full preliminary injunction briefings at a scheduled hearing, this court intervenes to relieve the government of its obligations under the order. So think about that. At the time this came down, the very next day was when Boasberg was going to have the fully briefed, fully argued issues about what had happened in the case. But the Supreme Court quickly jumps in and says, hey, we're vacating the TRO. They're not saying you can't have your hearing, but think about the ways in which that undermines the significance and the gravity of that hearing. Now, as I said before, the majority definitely says you have to be given hearings and notice. And they point that out and they say, I'll quote from a little screenshot here, "We have held that an individual subject to detention and removal under that statute, the Alien Enemies Act, is entitled to judicial review as to questions of interpretations and constitutionality of the act, as well as whether he or she is, quote, in fact, an alien enemy 14 years of age or older." So what that means is, in these future hearings, emphasis on the word future, they're going to get a review and people will be challenging whether the act even applies to me, whether I really fit this definition. Also, what the court isn't saying is that at some point in the future, courts are going to have to determine if it's even proper, legal, constitutional for Trump to use the Alien Enemies Act in this situation, right? It begs the question to say, I'm challenging the fact that I don't fit that criteria. I'm not an actual alien enemy. It begs the question of whether you can even apply the Alien Enemies Act to anyone under these circumstances for immigration reasons. But importantly, they say it can only be brought through habeas corpus, and that's sort of a mixed bag. It is a good thing for people in democracy that the Supreme Court says you got to get notice and hearing. There is some means of relief for people, but it's really good for the Trump regime because it says that the opinion says the cases must be filed in the detention state, not where they got picked up. So if all these people are sent to some holding place in Texas, for example, before they're going to be flown out, they have to make the habeas corpus petition down there in Texas. Now, that makes it much harder for them to get counsel, makes it much harder to be in touch with their family, and it makes it a far greater hardship on them as well. Importantly, it leaves completely fuzzy, at least to me when I read it, what is the status of those who were on those planes that didn't get turned around? They didn't bring a habeas petition originally, and they also got no judicial review. So notice some of the self-serving logic going on in the Supreme Court's decision, right? We aren't reaching the merits, they say, of whether it's okay to use the Alien Enemies Act. We're only talking about how you can challenge it. Well, some logic there, which is like if you were going to challenge it and you want a process review, you have to set that in the opinion, set forth how it's done. But you know something, Supreme Court, you wouldn't need any of that if you first found that it wasn't appropriate to use the Alien Enemies Act when we're not at war to deport people. Kind of a circular problem, right? And what you're really saying there in the majority decision is we're allowing this to be used. I mean, we'll think about it later if it's okay to be used, but this is how you use it. This is how errors can be corrected. That's why it's going to be really, really critical in a different case, which we'll cover later again, the Albrego Garcia case. That was the Maryland man who basically got disappeared and sent off to the El Salvadoran prison, where the U.S. has conceded, oh, we made a mistake in that case, but there's nothing we can do about that case. That's about correction, right? That's a habeas case, and it's going to come down to, if you order the United States to correct that error, then there's some teeth to this. But if you end up saying there that, oh, you can't do anything once it goes out, the person's gone out there, this is a meaningless circular opinion in that case. It may also be, could be sleight of hand, or maybe some fear on Chief Justice Roberts' part here of trying to duck something else. Professor Steve Vladeck, I'll put up the link to his Substack here, points this out, and it's worth looking at. Vladeck writes, "This isn't any old case. It's the case in which the government has come the closest to outright defiance of a court order, defying Judge Boasberg's order, and it's the case that led President Trump to call for the impeachment of a sitting federal judge. And not 2 weeks later, after Justice Roberts had sort of pushed back on Trump for calling for impeachment, here's Roberts providing the decisive vote to hold that, in fact, the case shouldn't have been before the judge, Boasberg, in the first place, without even a hint that any of the government's behavior warrants any reproach here. Very different than the dissent by Justice Sotomayor, in which she really calls out the government's behavior in the case, saying that their behavior with this litigation poses an extraordinary threat to the rule of law, that a majority of this court now rewards the government, her words, for its behavior with discretionary equitable relief that's indefensible, in her words. And interestingly, who joined that dissent, at least in part? Justice Amy Coney Barrett joined it. She joined the part of the dissent, parts 2 and 3. Part 1 was kind of more of the ranting and railing on the Trump administration. She didn't join that. Parts 2 and 3 is what really calls out, hey, why the hurry? What's the big rush to get this unusual intervention out when you normally don't even take on TROs? And that is really important, because the notice and review are good, but the haste that the Roberts Court acted to get in here and intervene kind of looks like the usual cover the conservative core of the court wants to give Trump, and perhaps hiding behind Chief Justice Roberts' attempts to avoid confrontation. He's afraid of that confrontation where the Trump regime, DOJ, speaking for them, says, we're just not going to follow your orders, Judge. And he's trying to undercut that possibility by basically pulling the rug out from under Boasberg's case to begin with. So that's kind of the reading between the lines analysis of what's going on here. But the important thing is, got to have notice, you got to have hearings. That's good for people going forward, unknown what it means for people that have already suffered these kinds of disappearances. So we'll keep an eye on this. Thank you for the replies in the comments. And again, don't hesitate to go to my personal website, which is up, www.shanwanwu.com, if you want to reach me there with any particular questions that YouTube doesn't allow us to converse about. So we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.